Parliament passed the Habeas Corpus Act of 1679. What is habeas corpus, and to what extent, if any, is it essential to the principle of limited government? How has the writ of habeas corpus evolved in the United States? Under what circumstances, if any, might the writ of habeas corpus place an unreasonable burden on the government? Whenever you're ready.
Known as the Great Writ of Liberty, habeas corpus brings a prisoner or detainee before the court and petition against unlawful detention, extradition, bail amount, or jurisdiction. The founders understood it as an essential element of English common law, thereby including it in the original body of the Constitution. The Fifth Amendment provides justification for the necessity of habeas corpus in that no person shall be deprived of life, liberty, or property without due process of law. Habeas corpus remains vital to upholding the rule of law as established by the Magna Carta in 1215. The framers of the Constitution prioritized the rights of the accused and procedural protections to defend against despotism. According to the Brown v. Vasquez decision, the writ of habeas corpus is the fundamental instrument for safeguarding individual freedom against arbitrary and lawless state action. Limited government avoids curbing individual freedoms except under extreme circumstances of rebellion or invasion, as stated in the suspension clause.
Article 1, Section 9 of the Constitution grants habeas corpus, while the First Judiciary Act of 1789 extended relief to those held in federal custody or accused in federal court. Ex parte Bowman held that the power to award the writ by any of the courts of the United States must be given by written law, limiting issuance by the Supreme Court to inferior federal courts. Congress expanded the court's jurisdiction under the Force Bill of 1833, which responded to the nullification crisis by allowing writs to federal revenue officers in state custody who acted in accordance with federal law. A similar issue arose over the Fugitive Slave Act of 1850, in which states arrested federal marshals for apprehending runaway slaves.
The Habeas Corpus Suspension Act of 1863 permitted Lincoln's Civil War suspension of habeas corpus, deemed unconstitutional by Ex parte Milligan, but required reporting and timely release. Reconstruction brought the Habeas Corpus Act of 1867 for those restrained of his or her liberty in violation of the Constitution or of any treaty or law of the United States. Subsequent court decisions narrowed this jurisdiction by forcing prisoners to exhaust all state remedies and prohibiting re-examination of state court decisions on constitutional questions. Habeas corpus became a post-conviction remedy for the first time in 1886 under Ex parte Royale.
Habeas corpus rights expanded following Supreme Court decisions that repealed the re-examination restriction and requirements that writs be issued only to courts lacking jurisdiction. In spite of this, contractions included the elimination of direct appeals, the codification of the exhaustion of state remedies, and the placement of the burden of proof on the petitioner. Stone v. Powell denied habeas corpus in instances where state courts provided for litigation on constitutional rights. Swain v. Presley and Coleman v. Thompson limited and then overturned Fay v. Noya, where the sufficiency of exhaustion did not consider remedies not available at the time of the petition.
National security conflicts with habeas corpus, and in the prosecution of enemy combatants. The Anti-Terrorism and Effective Death Penalty Act reduced the unreasonable burden on the government through a one-year limit on petitions and a ban on successive petitions. Both the Detainee Treatment Act of 2005 and the Military Commissions Act of 2006 barred Guantanamo detainees from seeking habeas relief from federal courts, instead instituting military tribunals. Boumediene v. Bush granted review as a constitutional right outside of the United States.
Expedited removal and immigration reduces backlog pressures on federal courts and the public defender system. Congress passed the Illegal Immigration Reform and Immigration Responsibility Act in 1996 to reduce review and appeals. DHS versus Thurasigiam ruled that limits on habeas review did not violate the suspension or due process clauses when in the context of asylum. Courts must weigh governmental burdens and the common good against personal liberty in maintaining robust habeas corpus rights. That's the end of our response. We are more than happy to field your questions now.
All right, nicely done. We'll go into a little conversation here and have you elaborate on some of your thoughts around this. So you touched on the evolutionary nature of habeas corpus in this country's history. Can you elaborate just a little further on the impact that's had on state courts or state governments? Having started as a federal issue, essentially.
Well, many of the original state constitutions, some of which came before the federal constitution, actually included a provision for habeas corpus, but this is somewhat inconsistent across the country because not all have a suspension clause.
Okay. All right, thank you.
All right, let me pick up there. Right, so a lot of interesting things. Take us to the border, right? I'm in California, and we've got a southern border, and we've got a contemporary crisis, some might argue. How does habeas corpus apply in the current situation of our immigration and asylum system?
One way that it would help in the immigration and asylum system is providing an important check on unlawful detention. One crucial example of this is sort of unlawful detention by the Immigration Customs Enforcement branch, which the judicial power of habeas corpus and being able to sort of present a warrant for that detention would be an important check.
One major issue that's happening at the border right now is we're seeing the accumulation of children who are not accompanied. They're unaccompanied minors. And so these children don't have the right to due process that an adult would. And therefore, they are lacking habeas corpus privileges and accumulating in detention centers.
Is that okay? Are you guys all right with what's happening? Evaluate a little bit. Should we fix it? How can we fix it?
I think in terms of a human rights question, I think there are some situations that are unacceptable at the border, especially with the treatment of minors. But under the Biden administration, there have been attempts to fix that. But with the overwhelming numbers of people trying to come over, they've been struggling with capacity and with the ability to place and naturalize all these children that are coming over. So I think there's no clear fix, but I think hopefully the attention that's being brought to it will help there become a new solution for this problem.
Great. Thank you very much.
Thank you.
Let's go back in history a little bit, back to the Civil War. You mentioned Lincoln's suspension of habeas corpus and the subsequent congressional acts. I think you guys laid the facts out on what happened, but I'm curious about your opinions. Do you think Lincoln was justified in his suspension of habeas corpus?
Constitutionally, Lincoln was not justified, but in a sense, since he received the approval from Congress after, the act in general was correct because we were in a state of war, and that's what the suspension clause provides for. So he did suspend habeas corpus in the territories between the North and the South.
I think in terms of what the suspension clause calls for, which is kind of broad in nature when it says that it calls for acts of public safety or when there's invasion or conflict. So I think if his actions were not technically legal at the time, I think they still were justified in terms of public safety and protecting the Union.
So then justified, this is for the whole panel, justified under public safety, that's what the suspension clause calls for. Well, then how about FDR with the Japanese internment camps in World War II? It happened after Pearl Harbor, after a state of war was declared. Was he justified either constitutionally or morally or ethically?
So I believe in what you're referring to is following Pearl Harbor, when FDR suspended the writ of habeas corpus and used that ability to intern Japanese American citizens. I think that in his actions, they were discriminatory because they were used specifically against all Japanese Americans, regardless of their actions. So in the court case in Korematsu versus United States, that was upheld. But I think that it's a very rough area because this was used in a discriminatory manner rather than a manner to actually genuinely protect American citizens in the war effort. So that was retracted in, I believe, ex parte endo in 1944.
So it was unjustified by the federal government, as Jack mentioned, because endo overturned the internment. because the federal government didn't have any probable cause, there was no proof that these citizens showed disloyalty to the government and that they would pose a significant threat during wartime.
And although it doesn't completely, fix the actions of the government, there was a compensation following Endo with, I believe it was $20,000 for survivors of internment.
Thank you.
Go back just a little bit. You referenced the due process elements of the Fifth Amendment, and one could add in the 14th as well. Maybe just expound briefly on how the writ of habeas corpus relates to, what's the relationship between due process in the Fifth and 14th Amendment and the writ of habeas corpus? How are they tied together? Or maybe they are. I mean, if you think they are, you can elaborate, or if you think they aren't, you can elaborate.
Due process allows for a citizen to move smoothly through the sentencing process without any unnecessary burdens, such as not having the right to counsel and being, specifically in the case of habeas corpus, being unjustly put into jail. And so what habeas corpus does, it's a petition against the government showing, here are the reasons why you have unjustly suspended my liberty.
The Fifth Amendment is definitely also tied with habeas corpus in that no protection against self-incrimination would retroactively justify a warrant for detention, which would obviate the purpose of habeas corpus.
And as you refer to the 14th Amendment, especially after having talked about internment and the Civil War, I think that those are also related, because it grants citizens the right to a fair trial and not being detained in an unjust manner.
We just have a couple
5
of
seconds, so we'll
couple
forego
of
another
seconds
question.
left, so we'll there's not time for another question, but
Time.
this me saying there wasn't time, then time came up. So anyway, nicely done, gentlemen. You were able to complement one another and add to each other's contributions and sort of build on that. You had solid citations and were able to pull case references, for example, to bolster a particular argument that you were making. And so that was impressive. Your understanding of your reference to state constitutions, I was found to be impressive as well, where you referenced when I talked about it moving toward a state issue as well when I asked that question. And so you did very nicely in that regard. So you're commended for that. I'm in your college work down the road or whatever, if you ever end up on this subject again, you can kind of further expand on the burden principle is now on the states. It's largely a state issue. Habeas is for state incarceration. So you can dig into that a little bit further there. So well done, gentlemen. And it was enjoyable to get to dialogue and converse with you, and wish you well down the road in this, and as well as wherever you end up going. All the best.
All right. Yeah, that was really enjoyable. The time flies when we're engaged in a conversation with, thoughtful young people who are beginning to really develop some sophistication. I have to say, your treatment of the evolution of the writ was, so beyond what I was expecting in terms of your level of detail and understanding. That was like a dissertation. That was fantastic. I even learned a couple things in there, and I'm just beyond impressed. I thank you for that. You clearly understand the importance of habeas corpus, right? You get it. You're like, hey, that's fundamental, right? If we're not going to have a tyrannical government, we've got to have these checks. So I appreciate that. And what you also understood is this is a huge tension, right? We've got the needs for our government to work, but we also need to maintain safety, and we also need to maintain our rights. That's the world we live in. It's not black and white. It's not simple. It's hugely complex. I guess what I was hoping you could follow, and it could have been my bad question. because you said that children weren't provided any kind of due process or habeas corpus. That's what I was asking. Like, do you care about? Like, do we care that that's applied differently to minors? And if not, what should we do about it? And then there's also the question fundamentally that you articulated earlier is like, well, these people aren't even American citizens, and how does that work out? But I think you understand that. Had we had another half hour to have this conversation, which would have been enjoyable, I probably would have learned some more. So I thank you all for your hard work, for your passion, and thank you, Mr. Thomas, for your hard work as well.
Yeah, I would. I had that written down myself in your remarks about how the writ has evolved over time. It was incredibly thorough and well supported in the evidence. I also have a note about the court cases that were mentioned in the case law, and again, just not rattling them off, but mentioning them for a purpose and then explaining what they meant and explaining how they tie into your argument. That was absolutely an effective use of the case law on your guys' part. And then the last thing that I think was very evident in your remarks and in the follow-up exchanges was understanding the tension here. I think you framed it in the beginning as the common good and public safety versus individual rights, and that's the meat of the whole thing. And it's messy and it's complicated, and there's no clean answers. And I think both in your prepared remarks and in the follow-up exchanges, I think you showed a respect for that messy nuance, which was again very effective. So well done, guys.
Good job, guys. And thanks to Mr. Thomas.
Thank you very much, judges.